Yes.
My please, Your Honor, I beg to mention hearing item 20 and 21. Here, my lord, I'd like to file an additional affidavit, so I'll be granted 3 weeks
20
time.
and 21.
2021.
Okay.
I'd like to file an additional affidavit, so 3 weeks time will be
Additional
granted.
affidavit,
Lordship.
government. Learned counsel for the petitioner, Shri S. Walling, submits that he may be given some time to file an additional affidavit. The prayer is allowed. List the matter after 3 weeks. Learned government counsel is present.
I also like to mention item 23, my lord.
23.
The matter may be come up on 15th of May.
Item 23. List the matter on 15-3, 15-3, no, 15-5.
My lord, again, item number 26, hearing item 26.
26.
It may be come up after a week.
26. List the matter after 1 week on the prayer of the learned counsel for the petition.
My lord, last day I have also a prayer of admission item number 1. Here, Your Honor, I filed an additional affidavit this morning. So let the matter may be fixed on 16th of May.
Item 1, admission, okay. Learned counsel for the petitioner, Shri S. Walling, submits that he has filed an additional affidavit
Affidavit, yes.
this morning and accordingly prays for listing the matter after a week
On 16th of
on
May.
16th. On 16th. You have received copies?
Yes, yes.
Okay, on 16th May.
My pleasure.
May I please, my lady, I beg to mention item number 15, 15.
Okay, hearing.
Yes, if it may, can it be listed next week, next Thursday, 15? I've taken the consent of the other party also.
I have no objections.
15, yes. Learned counsel for the government respondents, Shri K. Angami, has prayed for listing the matter on 16th,
15,
15th
Thursday.
Thursday. Petitioner's counsel has no objections. List the matter on 15th.
Pleasure.
Much obliged. May it
Anything
please,
else?
lordship.
Yes.
My lord, may I pray for adjourning the matter item 18, hearing
15.
from the hearing list. Let this matter come up on 15 for hearing.
Everything is coming up on 15. Give it another day.
Yes,
Yes,
many items are fixed on 15th.
yes, that's why. Even if it's fixed, it will never reach.
Let
Yeah.
it be some other day then.
Maybe the week commencing from 19th.
All right,
Yes,
all right.
list the matter on 19th May. The consent of the parties, okay? Yes.
Much obliged.
Much obliged.
My please, my lord, I beg to mention again hearing item number 19. Here,
19.
I would like to
Yes.
file an additional affidavit here. So 3 weeks may be granted again.
19. Journalist counsel for the petitioner prays for 3 weeks' time to file additional affidavit. Place the matter after 3 weeks. 19, okay?
My pleasure.
Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 9, Lordship.
9.
Lordship, here I'm for respondent number 1. I'm yet to receive instruction. Lordship, may I please to grant 3 weeks time, Lordship.
Government advocate Victor Zimomi prays for
3 weeks
3
time.
weeks' time to file affidavit in opposition. Where's the petitioner? Item 9, item 9.
Taking the call.
Yes, 3 weeks. To file
4 weeks,
affidavit.
Your Honor, lordship,
He's asking for
For
3
3
weeks.
2 weeks. No
3
problem.
weeks'
Oh,
time to file affidavit in opposition. Learned counsel for the petitioner has no objection. List after 3 weeks. Yes.
Lordship, I also beg to mention item number 12, Lordship.
12.
12, Lordship. Lordship, on the last occasion, Lordship,
Hmm.
endeavor should be met to file an affidavit in opposition. However, Lordship, I have received the affidavit in opposition only, instruction only yesterday, Lordship. But otherwise instruction, Lordship. So I may
How
allow
much
3 weeks
time?
time, Lordship.
2 weeks. Petitioner? Learned counsel for the government respondent, Shri B. Zimomi, prays for 2 weeks' time to file his affidavit in opposition. Prayers allowed. List the matter after 2 weeks. Learned counsel for the petitioner is not present on call. Stop. Yes. Yes.
Obliged.
Lordship, I'd like to mention one, this writ petition for posting of the matter on 16/5/2025. This matter was last heard on 12/9/2024.
It is related to this writ petition civil number 184 of 2023 relating to retirement benefits of one grade 4 employee, Your Honor, Lordship. And I have requested several times to the Standing Council of the government for accommodating me for this final hearing. But then for
Pleadings are complete.
pleadings, everything is complete, Your Honor, Lordship.
Okay, give it to the.
Much obliged.
Lordship, I beg to mention hearing item number 16 and 17. On behalf of additional AG V. Sokre, Your Lordship, kindly let the matter come up after 1 week.
16 and 17.
It can come up on the 19th then, my lord.
19th. Item 16 and 17, okay. Prayer has been made on behalf of MSV Shukri, Learned Additional AG, to list the matter. Next week, you said?
Yes, Your Lordship,
Next
after 1 week.
Yes. However, the learned counsel for the petitioner has paid for listing the matter on 19th May. Accordingly, fixed on 19 May.
Lordship, there's an interim here. if
The
you can make some-
interim order passed earlier shall continue till the next date.
Lordship,
Yes.
Your Lordship, item number 24, on behalf of V. Sokre, Your Lordship, additional AG, let the matter come up after 1 week, Your Lordship.
Item 24, place the matter after 1 week on the prayer of learned counsel appearing for the additional AG, Ms. V. Shukri. Yes, stop.
Much obliged.
Lordship, there's an interim.
Interim order passed earlier shall continue till the next date.
Much obliged.
May I please,
Listing
madam?
is
Lordship, I beg to mention item number 5 and 6, Your Lordship. Lordship, in these two matters, Your Lordship, I have certain clarifications with regards to the previous comment, Your Lordship. I'm here to receive those clarifications.
Hmm.
If these two matters can be listed after 3 weeks, my lord.
Shino, yes. Learned Government Council, Shri N. Angami, raised for how much time? 3 weeks.
3 weeks time.
3 weeks time to obtain certain instructions with regard to the pairwise comments received. Stop. Learned Counsel for the petitioner has no objections. Place the matter after 3 weeks. Yes.
Thank you, Lordship. Lordship, I beg to mention item 35. I'm for the respondent.
Okay.
Lordship, here I'm yet to file my affidavit also.
R5,
No, I'm the sole respondent,
so respondent.
item 25. Item 25 from the hearing list.
Counsel, Shri Foseko Fute appearing for the sole respondent and praised for how much time?
3 weeks time to
3
file my
weeks time
affidavit in
to file
opposition.
his affidavit in opposition. Learned Counsel for the petitioner is present. List the matter after 3 weeks.
Much obliged.
For motion, item number 28.
Who's this? Item 28. Who's appearing? One appears for the petitioner when the matter is called. List the matter next week. Next.
Obliged, my lord.
For motion, item number 29.
Please, your leadership. You should just may I take your leadership to the synopsis. The entire case is mentioned in the synopsis. May I read?
Yes, please.
The petitioners are the Kuki MP, the Nagaland Gaur Tribal Council, the Kachari Tribal Council, and the Karbi Mikir Council, hereinafter referred to as the Tribal Council's petitioners. They are the apex tribal bodies of the Kuki, Garo, Kachari, and Mikri tribes of the state of Nagaland. In the Constitution Scheduled Tribes Order of 1970, the aforesaid four tribes are the Naga tribe, and the Naga tribe are the recognized scheduled tribes in the state. The state of Nagaland has issued notifications from time to time containing instructions, orders for protecting the rights of the scheduled tribes notified by the Scheduled Tribes Order of 1970. The protections in this regard relate inter alia to public employment and ownership of land. In respect of public employment, by notification number AR dated 28/4/77, the criteria for obtaining the indigenous inhabitant certificate has been laid down. In the recent past, issues of concern arose regarding illegal immigrants, the issuance of fraudulent indigenous inhabitant certificates, and their adverse consequences for the people of the state. To deal with the aforesaid problem, by notification dated 29/6/19, the decision of the government to set up a register of indigenous inhabitants of Nagaland was notified. This was followed by a notification dated 27/7/2019, by which a commission was constituted for the purposes of the RIIN. The commission for the RIIN submitted its report sometime in 2020. Copies of the same were endorsed to all the tribal organizations in the state. However, as per media reports, the government decided that the report of the commission court will be given at the right time. Till date, no information has been disseminated regarding the decision of the government on the report. Subsequently, by notification dated 29/24, for the purpose of the RIIN, the government laid down the criteria for the issuance of the indigenous inhabitant certificate for the 15 recognized tribes, Naga tribes, and the Garo, Kachari, and Mikri. So this is the first notification, Your Ladyship, by which the criteria for the RIIN was laid down. And this is a criteria which is applicable to all the Naga tribes, including the four tribes. Thereafter, inexplicably, order dated 29/24, based on a cabinet decision taken on 11/9/24 was issued, stating that an enumeration exercise for determining the eligibility of the Garo, Kuki, Karbi, and Mikir tribes settled in the state of Nagaland prior to 1/12/1963 for the indigenous inhabitant certificate, permanent residence certificate would be undertaken. Here, if I may pause for a moment, Your Ladyship. So by the Scheduled Tribes Order, we are recognized tribes of the state of Nagaland. Scheduled Tribes Order of
Yes, the 1970.
Yes. So we are eligible for the indigenous inhabitant certificate. There is no question of saying that the four tribes will be enumerated for determining their eligibility for the IIC. So that is where things have started to go wrong, Your Ladyship. Then separate mention was also made for the enumeration of the Nepali Gurkhas permanently settled in Nagaland prior to 31/12/1940. This was followed by a notification dated 1/10/24 in relation to the enumeration exercise. The order dated 29/24 fixed a timeline for the purposes of the RIIN. It also contained a format for the indigenous inhabitant certificate, wherein the sole criteria mentioned is inclusion in the electoral roll of 5/12/1963. So if you may again pause here for a moment. Your Lordship is aware of the notification dated 28/4/1977. The criteria for the indigenous inhabitant certificate for the purposes of public employment. For the purposes of public. So what the order dated 110, the order dated 110, the order dated 29/24 and the notification dated 1/10/2024 have laid down is only one criteria. And that is
the
5/12/1963.
Electoral roll.
Yes. Thereafter, by a memorandum dated 9/10/24, the issuance of the indigenous inhabitant certificate for the Garo, Kuki, Kachari, and Mikir settled in the state prior to 1/12/1963 was reiterated. The objective for setting up the RIIN is laudable and in public interest. The criteria prescribed for this purpose as notified in a notification dated 29/24. So that is the notification which is applicable to all the Naga tribes, including the four tribes. However, the very purpose of the RIIN has been scuttled and reduced to an exercise of enumerating the Garo, Kuki, Kachari, and Mikir tribes to determine their eligibility for indigenous inhabitant certificate. That too only on the basis of inclusion in the electoral roll of 5/12/1963. The notification dated 29/24 envisages the RIIN for all the recognized tribes of Nagaland. The order dated 29/24 detracts from this notification, ignores the Constitution Scheduled Tribes Order 1970, and reduces the status of the Garo, Kuki, Kachari, and Mikir tribes to mere indigenous inhabitants. The animus towards the Garo, Kuki, Kachari, and Mikir by the state is glaringly visible. The order dated 29/24 states that the enumeration exercise will start by 1st December 2024. However, Your Ladyship, till date, the said exercise is yet to be initiated. Nothing has been done. Against the proposed enumeration exercise, the petitioners have met with the state respondents on multiple occasions and submitted representations dated such and such. The representations have not elicited any response. In recent meetings, with the state respondents, the petitioners have been informed that the enumeration exercise will go ahead. Still, but nothing has gone ahead. It is the case of the petitioners that they are recognized scheduled tribes of the state of Nagaland. Their status in this regard has been notified by the Nagaland Scheduled Tribes Order of 1970. As such, the state has no authority in law to reduce the status from recognized scheduled tribes to that of mere indigenous inhabitants. As recognized scheduled tribes, the petitioners are eligible for the indigenous inhabitant certificate. Therefore, the enumeration exercise for determining their eligibility for the indigenous inhabitant certificate is not an exercise in public interest, but a motivated and mala fide exercise. The cabinet decision dated 11/9/24 and memorandum dated 9/10/24, the order dated 29/24, and the notification dated 1/10/24 are therefore arbitrary, discriminatory, illegal, and unconstitutional. Hence, this application praying for the indulgence of this honorable court. Now, at this point, Your Ladyship, if you may go to the notification of 29/24,
Okay.
page 83.
Page
83. Page 83.
this.
May I read, Your Ladyship? This is dated 20th September 2024. In order to protect and safeguard the interests of the indigenous inhabitants of the state of Nagaland, kindly note the language also, Your Ladyship. The indigenous inhabitants of the state of Nagaland, and for the purpose of streamlining the qualification for eligibility of being an indigenous inhabitant of the state of Nagaland, and taking into account the recommendations made by the Commission of RIIN, and considering all other relevant aspects of the matters and in supersession of all the previous notifications, guidelines, and orders issued from time to time by the government on this subject, the following criteria are laid down for issuance of IIC. IIC of Nagaland can only be issued to citizens belonging to any of the 15 recognized Naga tribes, namely the 15 Naga tribes, with, at the fourth line, has the Lordship got it?
Yes.
With Kachari, Kuki, Garo, and Miki
Garo.
tribes, as notified by the Constitution Tribes, Scheduled Tribes Order of 1970, who are present in the state and are considered as indigenous inhabitant of Nagaland, provided that the person can trace their antecedents to a recognized village in Nagaland. All very good, Ladyship, all very good. There shall be in every recognized village and the modalities. But this is the criteria which has been fixed. And for all the Naga tribes as well as the 4 other tribes, Kachari, Kuki, Garo, and Miki. Now, this is very good. We have no objection to
This
this.
is okay, yes.
Yes, we have no objection to this. But this was followed by an order on the same date, 29, page 100. Page 100.
This is also 29.
Yes, same date,
Yes.
same date. But this is an order. The earlier one was a notification,
Yes.
and this is order.
Mm.
May I read it?
Yes.
Whereas in the pursuance of a cabinet decision dated 12/9/24, with regard to eligibility criteria of being an indigenous inhabitant of the state of Nagaland and issuance of indigenous inhabitant certificate, an enumeration exercise is to be conducted of the people of the direct descendants from Garo, Kuki, Kachari, and Mikir settled in the state of Nagaland prior to 1st December 1963, so as to determine their eligibility for issuance of IIC, PRC, the enumeration of Nepali Gorkhas who are permanently settled in Nagaland prior to 31st December 1940 and their direct descendants will also be conducted simultaneously. And the enumeration exercise, the modalities for that, and the timeline at the bottom of the page, it's at clause 5. Has the Lordship got that?
Yes.
So this timeline is not being adhered to. We are way past this timeline, but this notification is still alive, Your Ladyship. And this was followed by, and there is an enumeration format annexed to this, Your Ladyship, and this is at page 102. And
This one.
in the fourth column, third and fourth column is joint, Your Ladyship,
Third and
electoral roll of 5/12/1963.
fourth.
Electoral roll of 5/12/1963. This is the sole criteria which has been fixed. Firstly, Your Ladyship, this enumeration exercise is only for the 4 tribes and the Gorkhas, not for the entire, not for all the tribes settled in the state of Nagaland. And then this was followed, Your Ladyship, by a notification dated 1st October 2024, which is at page 106. Type copy is at page 109.
Yes, what is this?
107, 1st October 2020, in pursuance of order dated 29/2024. That is the previous order which we were just referring to, Your Ladyship. From the Home Department, Nagaland, an enumeration exercise to be conducted of the people in their direct spelling from Garo, Kuki, Kachari, Mikiri, and Nepali Gorkhas settled in the state of Nagaland as mentioned below for issuance of IIC, Indigenous Inhabitant Certificate, and PRC. Garo, Kuki, Kachari, Mikir, Karbi settled in the state of Nagaland prior to 1st December 1963. Nepalis, Gorkhas settled in the state of Nagaland prior to 31st December 1940. And then the bottom of the order, scheduled for the enumeration exercise, issue of notification 1st October 2024. Nothing has been done. Nothing has been done.
No.
So the point is, Your Ladyship, so even the states know, even the state knows that there is something wrong. And they have not acted upon the notification or the order.
Maybe they would say because Garo, Kuki, Kachare and all they stay outside Nagaland also, some of them.
Yes.
So maybe they wanted a mechanism to, check that. But then the way they have gone about
In fact, that was the argument that was thrown to us when we had discussions with the state. And we said, just like the Garos, Kukis, Kacharis, and Karbis, the Nagas are settled beyond the boundaries.
Yes, yes.
Nagas are settled beyond the boundaries.
Yes, yes.
So that logic doesn't apply.
Yes, doesn't apply.
And if it is to be a register of indigenous inhabitants of Nagaland, it must include all the tribes. We are not against that. And we are fully in favor of the notification of 2024.
September, that first one. Yes.
So that notification must be applied across the board. That is what we want, Your Ladyship. But why are we being singled out?
There they have said that provided that the person can trace their antecedents to
Yes,
recognize
yes.
age. So that will
Yes.
suffice actually.
And not only that, there is, Your Ladyship, if you might draw your attention to paragraph 6.1, there's another very interesting development as far as the 4 tribes are concerned.
6.1.
Yes, at page 10. Because all this doesn't seem to be a random act, Your Lordship. Something seems to be happening, something seems to be brewing. 6.1. The criteria for the indigenous inhabitants prescribed by the notification dated 28/4/77 is being used by the government for the issuance of scheduled tribe and indigenous inhabitant certificates. This fact can be ascertained from memorandum number such and such, dated 21/3/2011. Can we go to this memorandum, Your Ladyship, annexure 10, which is at page 64. May I read, Your Ladyship?
Yes.
Dated 21st March 2011. Guidelines for issue of scheduled tribe certificates and indigenous inhabitant certificates in the state of Nagaland. In supersession of this department's letter dated 2/6/2009, and in pursuance of the decision of the cabinet decision dated 14/5/2009, the governor of Nagaland is pleased to order that the following guidelines shall be strictly adhered to in the process of verifications and issuance of scheduled tribe certificates and indigenous inhabitant certificates to indigenous inhabitants of the state. Now, clause 3. Scheduled tribes certificates, indigenous certificates should be issued only to bona fide indigenous Naga tribes of Nagaland as notified in notification dated 28/4/77. So here the 4 tribes are left out. So there is some mischief which is brewing and the 4 tribes are being targeted. For what purpose? Only the state can answer. But we don't want to be targeted like this, Your Ladyship. We are all for a register of indigenous inhabitants of the state of Nagaland, but it must be for all the tribes. And the enumeration exercise also in that regard must actually be for all the tribes. The excuse or the argument that we are living across the border, that doesn't apply to us alone. It applies to all the Naga tribes also. And I made a specific statement to that effect, Your Ladyship, in paragraph. At paragraph 26. Paragraph 26. At page 24, Your Ladyship.
Yes.
Page 24. 26. That the Naga tribes are settled in Burma, Myanmar, and India. Within India, the Naga tribes are settled in Assam, Nagaland, Manipur, Arunachal Pradesh, and Meghalaya. In similar manner, within India, the Kuki tribe are settled in Manipur, Nagaland, Assam, and Mizoram. They are also settled in Burma. The Garo tribe are settled in Assam, Meghalaya, and Nagaland. The import of this indisputable fact is that the Naga tribes are settled beyond the state of Nagaland, and the Garo, Kuki, Kachari, and Miki tribes are also settled beyond the state of Nagaland.
So ultimately, what is your prayer? Your prayer
The,
is.
the order and the
to
notification,
caution to decide.
yes, the order and the notification dated first 10, we're challenging that, Your Leadership. The cabinet decisions, we say that we must be enumerated, we're challenging that.
Mm.
And we are saying that if at all an RIN has to be done,
Mm.
it has to be done in terms of the notification of 20th September.
Mm.
Across the board, for all the indigenous inhabitants of the state,
Mm.
and not just the 4 tribes.
Secret appropriation.
And then the memorandum, which I just referred to, Annexure 10, Your Leadership, we are asking for a correction of that memorandum to bring it in line with the Scheduled Tribes Order of 1970.
Yes, who accepts notice? Yes. Will issue notice.
Lordship, the final publication of the dues enumeration, as per the order, 20th September 2024,
Mm.
was 6th May this year.
Mm.
So I have to take instruction. So
I think-
But nothing has been done.
I think it is.
Yes.
Nothing has been done. You're pressing the interim prayer also.
Yes, yes, Your Leadership.
Lordship, interim will be heard after issuing the notice, because this matter,
The fact of the matter, Your Leadership, is that
No,
nothing has been
Lordship-
done so far.
this matter shall have a far-reaching effect, cascading effect.
No, not till the next returnable date. It will not harm you. Because in spite of the timeline, nothing has been done.
Now, whether
Mm.
we have done or not, then we'll
Mm.
explain. So and this may be issued, because it is our job. Whether the publication enumeration was done or not, today I cannot, unless.
I have a
instruction
sworn,
is certain,
I have
cannot
I have
advise
filed
you.
a sworn affidavit, Your Leadership, I will stand by that. Till today, no exercise has been undertaken. In fact, it would be fair even to concede that, Your Leadership. Everyone knows that no exercise has been undertaken till today.
Lordship, there is no urgency at all. So a time will be given. Issue notice, and let me obtain the necessary instruction.
We'll give a short notice,
Yeah, that's very good.
2 weeks.
Lordship.
And in such matters, proper instruction has to be obtained on the next date, no?
Lordship, it will be 3 weeks. Because there is
3
not
weeks.
much difference 2 and 3.
Then why not 4 weeks?
This-
Okay.
Not much is difference between 2 and 3, so 3 and 4 also. Acha, this writ petition has been filed by, who are the petitioners?
Cookie,
By the Kuki
MP.
MP Nagaland, the Nagaland Garo Tribal Council, the Kachari Tribal Council Nagaland, and the Karbi Union Nagaland. Stop. Heard learned counsel for the petitioner, she is Imomi. Stop. The petitioner is aggrieved by the order dated 29/2024, page 100. Passed by the Home Department political branch, by which it has been directed in pursuance of a cabinet decision dated 12/9/2024 that there shall be an enumeration exercise to be conducted of the people and their direct descendants from Garo, Kuki, Kachari, and Mikir, under bracket Karbi, settled in the state of Nagaland prior to 1st December 1963, so as to determine their eligibility for issuance of IIC/PRC. Stop. In the said order dated 29/2024, a timeline, a schedule has also been notified by which the enumeration exercise was to have started from 1st November 2024 till 31st January 2025, and the publication of draft list to be issued on 15th February 2025, and thereafter for claims and objections from 17th February 2025 to 17th March 2025. Stop. The final publication of the list of enumeration was to be published on 6th May 2025. Stop. However, the petitioner states that the exercise has not commenced and nothing has been done till date. Stop.
Your Ladyship, there's another one. The notification dated 1st October 2024, which followed that
That one
again.
is
At page 106. And fixing another timeline. Because in consonance with the earlier order, but then
page 106, yes. So the petitioner is also aggrieved by the notification number CN/CON/RIIN/2019 dated 1st October 2024, by which same thing, this one also
yes, yeah.
is by which it has
The
been
aforesaid
stated
timeline was
that
reiterated.
yes, by which it has been stated that in pursuance of order number CON/RIIN 30/2020 dated 20th September 2024, the enumeration exercise is to be conducted for the Garo/Kuki/Kachari/Mikir under bracket Karbi and Nepali/Korkas settled in the state of Nagaland as mentioned below for issuance of IIC/PRC. And in this notification dated 1st October 2024 also, the schedule has been given for the enumeration exercises. Stop. It is the case of the petitioner that the petitioners are notified as scheduled tribes of Nagaland by the Scheduled Tribes Order 1970. And they are similarly situated with all the scheduled tribes of Nagaland. And therefore, the state respondents have no jurisdiction/power to take away the status of the petitioners as scheduled tribes of the state of Nagaland. Stop. Next paragraph. Learned Additional AG, MTM Song, has accepted notice on behalf of all the state respondents, all the respondents. Stop. Accordingly, no formal notice is called for at this stage. Stop. The petitioner has also prayed for an interim order staying the operation of order dated 29/2024 and notification dated 1/10/2024 pending disposal of this writ petition. Stop. List the matter after 3 weeks as prayed for by the learned additional AG, on which date the prayer for interim shall be considered. The respondents are also at liberty to file their affidavit in opposition if so advised.
Your Ladyship, an interim or projection,
We'll consider the next date.
3 weeks,
After
anything may
3
happen,
weeks.
anything may happen within 3 weeks, Your Ladyship. In the ad interim,
Lordship,
We
Your Lordship, it depends on the nature of the case.
no,
As when the
I-
party seek
No, no.
interim. So this nature of the case doesn't attract the interim. So
Sir-
3 weeks may be allowed to. Let me obtain the instruction. Without obtaining instruction, I cannot apprise another court.
No, we'll just say till the next date, the respondents shall not
Proceed with the enumeration.
proceed with the enumeration. Shall not proceed with enumeration till the next date. Yeah. Since you have not done anything till now, it shouldn't harm you.
No, whether
Yeah.
it is done or not,
Uh,
let me, I will be allowed to attend the instruction.
No, till the next date only. So on that date, court will consider again. Whether to extend or
That will
not,
pass in
whether
brief.
to, yeah. What did I say last? Till the next date. Then after that, till the next date, the state respondents shall not undertake any exercise with regard to the enumeration. Yes.
Much obliged.
Item number 30.
Yes,
Maybe this, Your Lordship.
yes.
Lordship, this case is pertaining for regularization. The petitioner was appointed as a typist on contingency basis, Your Lordship, under the establishment of assistant public prosecutor. And thereafter, she was also granted scale of pay, Your Lordship. In this petition, she is praying for regularization. She has completed more than 34 years of service, Your Lordship, in this.
Okay. So you're relying on the notification of 17.3 and 5.3.
Yes, Your Lordship, under Office Memorandum 17/3/2015, which is in page number 33, Annexure 6. Page number 33, Annexure 6. In Roman number 1, clause 1, it's clearly stated that, Your Lordship, Mayor,
Who have completed? Yes, please read.
all existing work charge and scheduled employees of various departments who are enjoying scale of pay and who have completed 30 years or more of continuous service as on 1/1/2015 will be regularized by conversion of their posts into regular ones, personal to them and subject to fulfillment of conditions and indicated herein below, Your Lordship.
In pursuance of these OMs, the departments have been asked by the PNR department to submit the names. Your
Lordship.
name has not been given
Your Lordship, we have not been notified about that, Your Lordship.
because all the departments were asked to send the names of those qualified persons actually in pursuance of this notification. And especially after this 5/2, what was the
5/3,
second? Yeah, 5/3
2025.
to the 25 also. So the department has not included your name.
Your Lordship, we have not been
The-
notified on that.
Because that exercise was going on from the beginning of this year, and PNR was collecting all the names of those qualified persons.
Lordship, I'll be
Anyway.
retiring on 8th of August this
Mm.
year. I'll be completing 35 years of service. And I'm covered under both the notification as well as the office memorandum.
This writ petition has been filed by the petitioner, praying for regularization of the petitioner's service as a typist in pursuance of the notification dated 5/3/2025 and no, wait, first you come to office memorandum, OM number AR-3/GAN-201/2009 dated 17/3/2015 and notification number AR/legal -8/2024 dated 5/3/2025. Stop. Heard learned counsel for the petitioner, MS, let me search. Stop. It is stated that the petitioner was appointed as a typist on contingency basis by an order number law LAW-115/81 on the bracket 3 dated 13/8/1991. Stop. It is stated that the petitioner has now completed, where have you stated?
34 years of service. Your Lordship.
Now, where have you stated? Where is that in your petition?
Your Lordship, in paragraph number 2, page number 5.
Okay, that the petitioner is now rendering continuous service for more than 34 years. Stop. However, her case has not been considered for regularization on the basis of the aforementioned office memorandums. Being aggrieved, the petitioner has approached this court. Stop. Next paragraph. Learned Government Counsel, Ms. Such appears for the, has accepted notice for the respondents number 1, 2, 3, and 4. Hence, no formal notice needs to be issued. Stop. List the matter after 4 weeks. The learned government advocate shall receive instructions and file affidavit in opposition.
Item 31.
Your Lordship, even in this writ petition, the petitioner is seeking for similar prayer. Regularization. He's serving as a sweeper on contingency basis, Your Lordship, under District and Station Judge Walker.
How many years this one?
She has completed 35 years of service.
Actually, for this, now all the staff of the district judiciary has come under the High Court. So
Okay.
you will have to implead the High Court also. Yes. They are now under the High Court. One, two, three, four. You have impleaded only the government respondents.
Lordship, if we may allow to withdraw and file afresh, we'll
Yes,
amend it.
you do that.
Lordship.
Petitioner is allowed to withdraw the petition with liberty to file afresh.
Oblige, Your Lordship.
For motion item number 32.
May it please, my lady. The petitioner is before this honorable court praying for regularization or appointment of his ad hoc service in the Department of School Education. He was appointed on land owner basis in the year 2011, 11
Land
July
owner
2011,
basis.
on land owner basis. However, that was on ad hoc basis.
Mm.
Now, there's no dispute to the fact that the petitioner and the landowners have donated the land free of cost without availing any compensation whatsoever.
Mm.
On the promise and on the agreement, oral agreement that substantive grade 4 posts or substantive posts will be given to the landowners in lieu of the land donated.
Mm.
Now the petitioner is before this honorable court for his due entitlement for regularization on the basis, on the strength of the office notification, the state government's policy, 5th March 2018.
5th March 2018. Which one is this?
This is at page 25, maybe. Next to H. More particularly 3B. Clause 3B of the notification. This is with regard to
No,
when
this is
there's
only regarding appointment.
appointment, yes.
But this doesn't say anything about
Yes,
regularization.
yes, exactly.
Yes.
When the petitioner was, so in this petition, we are not asking for retrospective appointment or retrospective regularization. We are just asking for, praying for regularization on the basis or fresh appointment on the basis of this clause 3B from the date of the order.
And here, I think there is a clause where it says that before 2000, yes, before 2020, 2005. So when did you donate the land?
1960s.
1960s.
The school was established in 1960s.
And there's an agreement, or there's no
On the,
agreement?
there's no specific written agreement
Oral
on the basis of an oral agreement.
For that, some procedure is there.
Yes, as per the 3B, we are okay.
Yes.
If this honorable court is willing to dispose of the petition today itself, also with the direction
Yes.
that on the basis of,
So the
Clause
deputy
3B.
commissioner
yes,
can
Make the
refer it,
verification.
refer it to the
yes.
land revenue and all that. Okay. Um, Lieutenant Counsel to Shilong Kumar. Stop. The petitioner is before this, will dispose it of, okay? With the direction to the respondent to consider under this 3B
Yes.
and to pass order. Okay. What did I say? The petition is before the court, yeah, before this court. Praying for appointment on the land ownership on the strength of the office memorandum bearing number LR, capital letter LR/6-181/LIT/2015 dated 5th March 2018. Stop. The case of the petitioner is that during the early 1960s, the landowners of Umma village had donated land to the government for the establishment of educational institutions wherein the existing government middle school Pongentula, Pongentula, Mokokchung, is situated. Stop. It is stated that the land was freely donated to the government of Nagaland on the specific condition that grade 4 post will be provided for the landowner. It is stated that no compensation was claimed for the same. Stop. Where is your letter saying that, order saying that you are the landowner?
Page 15, annexure B is the landowner certificate.
Okay.
Yes.
The petitioner has enclosed a copy of the land ownership certificate at annexure B, whereby by a letter dated 15, is this 15?
Yes.
15/1/2009,
2009.
the secretary of the Pongan clan, Pongen, Pongan clan, Umma, has certified that the present petitioner is a landowner. Stop. That means no one has been appointed till date.
He's working on ad hoc basis, Your Honor.
Oh.
My lord.
Mhm.
This is the recommendation on the basis of landowner, and accordingly, he applied for an existing vacancy, retirement vacancy. And he has been
It is,
serving for the
stop,
past 13
yes,
years.
okay, stop. It is also stated that the petitioner, on the basis of such certificate, was appointed on ad hoc basis as what?
Peon,
As peon,
office peon.
as office peon, vide order number ED/EST/A-1/2011-12 dated 11th July 2011. Stop. It is the case of the petitioner that on the basis of the said notification dated 5th March 2018, his case should have been considered for regular appointment on the basis of land ownership. Stop. The petitioner therefore prays that a direction may be given to the state respondents to consider the claim of the petitioner in terms of the notification, in terms of clause 3B, in terms of clause 3B, small b, of the notification dated 5th March 2018, and to appoint the petitioner on regular basis as a landowner as per the existing policy. Stop. This court is of the view that the present writ petition can be disposed of at this stage with a direction to the respondent number 1, 2, and 3 to consider the case of the petitioner in terms of clause 3B of the notification dated 5th March 2018. Stop. The respondent number, no, actually this is DC. You have not implemented the DC, no?
No.
The respondent number 3 shall issue necessary instructions to the Deputy Commissioner of the concerned district in order to verify from witnesses and also from government officials and the district administration, as well as village functionaries. And thereafter, dispose of the same by a speaking order within a period of
6 months. Lordship.
within a period of 6 months. Learned government advocate, MS such and such, appears for respondent number 1, 2, and 3. With the above mentioned directions, this petition stands disposed.
Item number 33.
My lady, here also similar prayer. Just that the school is different, the landowners are also different.
Here also oral.
Yes,
You should have made the DC a party actually, DC of the concerned district, no? Because as per that OM, it's the DC who will make
yes,
the
that was
exercise.
considered, but then
Ah.
it will be proper if the principal director issue a
Yes, yes,
direction to
of
the
course they
DC.
will do that. Same order then, but petitioner's name is different. And then
School will be different.
school will be different. Yes. You just see from the records. You're here also, same government council, applying for responding number 1, 2, and 3.
Item number 34.
Here also similar prayer.
Same school, this one also.
Different school. This is with regard to Sinangba Government High Secondary School, Kohima. The landowners
And
also
here also ad hoc
Yes,
ad hoc.
he is serving as ad hoc for the past 13 years.
Here also same order, different school. Appointment order also will be different.
Obliged,
I
my
like-
ladies.
For admission, item number 2.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention on behalf of Thibapom Lordship.
Mm.
If 3 weeks time may be granted to me to file my affidavit in opposition, Lordship.
Prayers been made on behalf of Shri Tiba Phom, learned government advocate, for 3 weeks' time
3
to
weeks time.
file affidavit in opposition.
Your Lordship, there's an interim.
Yes, yes. Prayer is allowed, list the matter after 3 weeks. The interim order passed earlier shall continue till the next date.
Obliged, Lordship.
Item number 3.
Perhaps Lordship. Lordship, my senior has some difficulties, so matter come up after 2 weeks.
Last order is 10/4/25. There it says that the court has directed for some verification, isn't it?
Yes, from the government.
The deputy commissioner shall submit the joint verification report. Where's the government council?
Mr. Tiba.
Oh, Tiba is
Tiba.
appearing. The court has directed on 10/4/25 to submit the verification report. And after that, only the maintainability question shall be considered. Next date then. When
After 2 weeks,
the prayer of the Learned Council for the petitioner, Shri Foseko, who submits that, who's your senior?
people.
That his senior PP Paul has some difficulties today and accordingly prays for listing the matter after 2 weeks.
Lordship.
It is seen from the order dated 10/4/2025 passed by this court that the Deputy Commissioner Dimapur was directed to submit the joint verification report pertaining to the land involved in the case in a seal cover on 8/5/2025 without fail. Stop. The Learned Government Council, Mr. Tiba Pom, appearing on behalf of the state respondents, is absent today. Stop. Accordingly, list the matter after 2 weeks, on which date the Learned Government Advocate shall produce the joint verification report. Mr. Tongpo Ponguner appears for the respondent number 5, no? Respondent number 5.
Obliged, my lord.
For admission, item number 4.
May I please, Your Lordship?
Yes.
Lordship, here the pleadings are completed. Date may be fixed for hearing, Lordship.
Some rectification, you've done it?
Yes, I've received this morning.
Okay. Heard Learned Counsel for the petitioner, Nolovulo. It is stated that the pleadings are complete and accordingly the matter may be listed for hearing
After 3 weeks, Lordship.
after
3 weeks.
3 weeks. Is the matter for hearing after 3 weeks.
Obliged.
Learned
Much
Counsel
obliged.
Futsiko appears for
3. R3.
respondent number 3.
Obliged.
Much obliged.
Item numbers 7 and 8.
Please, Worship. Worship, in this matter, we are supposed to file our affidavit in opposition in the IA.
It is made clear that no further adjournment shall be granted to file objection and IA shall be heard on the next date with or without objection.
Your Worship, I have received the one copy of the IA, but on the post it has come a bit damaged. And also the affidavit portion has some error. which is not as per the guidelines of this Honorable High Court.
Hmm.
So I pray that some time will be given for rectification and refiling of the same.
I have no objection.
2 weeks,
2 weeks before.
3 weeks.
Yes.
This is IA 198, na?
Yes, 19, there are two IS, same,
Two IS.
on the same issue. Since there are two appeal,
Okay.
and here the applicant is the respondent number 2 and 3 in the main appeal.
Mr. N.K. Luckham is present for the applicant. So, learned counsel Z.
Kulno.
Z. Kulno, appearing for the opposite parties, has prayed for somewhat for 3 weeks time
3 weeks time.
to file written objection, as the instructions which has been received by him is not in proper format, and he needs to what?
Rectification.
He needs to rectify the same. So accordingly, list the matter after 3 weeks.
For admission, item number 10.
Lordship, I'm appearing on behalf of respondent number 2. I've already filed my.
Yes, that case.
Yes, that's compromise case. We are praying for passing after the
No objections, no?
No.
This is your affidavit. 9265. We'll dispose it.
My lord.
Any submission, yeah.
Yes, this submission is that charge sheet involves two non-compoundable
Compoundable,
offense. So
yes.
there should be a full trial, but if it's subject to your lordship's
Yes.
satisfaction, I mean, like if there is exceptional circumstances.
Yes, when there is a settlement and even if trial is conducted,
Lordship,
the thing is whether it will result in conviction or not.
that is up to you.
So.
On that, my lord, I may be allowed to place one citation on the same principle that my lord has just pointed out. Narendra Singh's decision, paragraph 33. And only section 452 is non-compoundable. The other sections are compoundable offenses.
And 323 is not compoundable, your lordship, voluntarily fucking heard.
323 and
452.
452.
Yes.
Learned counsel for the petitioner, Sentianga, Pokim Yaden for the respondent number 2, and Miss S. Mary for the state respondents. Stop. This is a petition under section 528 of the BNSS, bring for quashing of the proceedings in GR case number 38/2023 in connection with Mogokchung PS case, Mogokchung PS2 case number 15/2023. It's okay, you can sit under section 447, 448, 323, 34, 427 and 452 IPC. Stop. It is the case of the petitioner that during the pendency of the proceedings before the court, before the trial court, the petitioner / accused and the complainant / respondent number 2 has amicably settled the matter by executing a compromise deed dated 6th February 2025. Stop. by the said compromise date, comma, it was stated that the respondent number one,
Respondent number two, one is that.
oh yes, respondent number two, being the first party, has no further interest to prosecute the second party, within bracket petitioner accused, okay, in connection with the Mokokchung PS2 case number 0015/2023, which is pending trial before the learned CGM Mokokchung. Stop. It was stated that all the parties are members of the same village and they wish to live together in a spirit of peace, harmony, and cooperation. Stop. The respondent number two has entered appearance and has filed an affidavit wherein it is stated that the respondent number two has no objection if the FIR dated 28/2/2023, comma, the charge sheet dated 13/12/2023, and the criminal proceedings against the petitioner in GR 38 of 2023 is quashed by this court. Stop. It is further stated in the affidavit that the petitioners and the respondent number two have reconciled and being members of the same village desires to live in peace and harmony with each other. Stop. Next paragraph. The learned counsel for the petitioners has also relied on the case of Narinder Singh and others versus State of Punjab and another, reported in 2014, 6 SCC 466. Stop. Acha, before that, before this para, you say learned PP, Ms. S. Mere, states that section 323 IPC and 452 IPC are non-compoundable, and therefore on this ground alone, the petition should be dismissed. Then you come to that judgment. 2014 6 SCC 466, wherein at paragraph 33, the Honorable Apex Court has observed that
From the portion where.
when there is a compromise between the parties, there is a minimal chance of the witnesses coming forward in support of the prosecution case. And therefore, the chances of conviction are remote in such cases, and it would be unnecessary to drag the proceedings. Stop. Learned counsel therefore submits that the present case is also covered by the said judgment, and accordingly prays that the proceedings of GR case 38 of 2023 pending before the learned CJM Mokokchung may be quashed and set aside. Stop. Next para. This court has considered the submissions of the learned counsels for the parties and has perused the readings as well as the trial court records which are before this court. Stop. It is also observed that the petitioners and the respondent number 2 / informant has entered into a compromise and have already settled the matter amicably. Stop. Accordingly, this court is of the view that conviction would not be possible, that the chances of conviction are remote in the present case, and it would be unnecessary to continue. It would be unnecessary to continue with the criminal proceedings before the learned trial court. Stop. Therefore, in exercise of the power under section 528 of the BNSS, the proceedings under section in GR 38/2023 pending before the learned CGM Bokchung is quashed and set aside. The petition stands disposed accordingly. Any interim order?
Yes.
The interim order shall stand merged with the present order. With the order is to
Much obliged.
and send back the trial court records.
Much obliged.
Item number 11.
His Lordship. Lordship, I beg to mention on behalf of Kiba Lordship. If this matter can be fixed on the 13th Lordship, sorry.
13th.
13th of.
So, my lord,
Mm.
here,
Counter affidavit also has not been filed.
Your lordship, whether that is filed or not, this is a different case that has to be understood from a different perspective. If it is a normal case, your lordship, then I would not have insisted. If they want time, let them take time, but at least status quo be maintained because there is a lot of mischief in this case, your lordship. In the first place, my lord, the work order dated 14 January 2025 was issued by applying the unknown yardstick in law. Contract is such that everything should be within the NIT. Now, my lord, in the NIT, the conditions which are not stated in the NIT, some unknown procedure was adopted to give the work order in favor of the respondent number 4, my lords. So, your lordship, even the work order which is supposed to be uploaded in the website, it was not uploaded. So on 27th of January, RTI was applied. Only after that we could get the work order, and the petition was filed after that, after preparation was made after that. So, your lordship, why interim was not granted on the first date is on the apprehension by this honorable court that work may have started. If not, prima facie by order dated 21/2/2025, my lord, prima facie illegality has been detected by this honorable court. So, your lordship, there was a submission made by the parties, the opposite parties, that work has commenced. When the affidavit was filed by my learned friend for the respondent number 4 on 21st of April, 2025, your lordship, the engineer's report, work report, progress report shows that it's 0%. So, my lord, in the last 1 week, in the last 1-2 weeks, in a rush to, since there is every apprehension, of course, I'm not saying that I'm winning the case, but as per the law, if we go by the law, the respondent number 4 knows that he has a weak case. So now, in the last 2 weeks, he has very hurriedly, he has already constructed 3. Your lordship, he's trying to construct the work in the meantime while taking time before this honorable court. That is continuing, your lordship. So, my lord, at least status quo be granted. I will not object if they take time, but it will lead to miscarriage of justice, my lord.
No, but then in the order dated 21/2/25, this court has said that the respondent may continue with the work
at his own risk and cost. But my lord, if more works are done in the meantime,
Simple reason that there is a one order of stay.
If I may, Your
it will
Lordship.
create more complications, Your Lordship.
Lordship, I am
Yes.
appearing on behalf of my senior representing the private respondent.
Yes.
So in the last affidavit which we have filed, we have stated that the clients have stated that the earthwork out of the 15 kilometers, 13 kilometers have been done. Also,
In fact, that is also misleading, Your Lordship, because the next year the document will say, I wish her senior was present because I don't want to take advantage of junior appearing in the case, Your Lordship. But if this continues, there will be miscarriage of justice, Your Lordship. So at least status quo may be granted while granting time, my lord. I have no objection to that.
we have also
Time
received a
taken,
new
Your
work
Lordship.
progress report just yesterday, Lordship. So when we file our counter affidavit, we will be annexing to that as well.
Your Lordship, this cannot
Wait,
continue. This is a
give
contract
short date.
matter.
Give short date.
But status quo may be granted, Your Lordship,
No,
because they are
when-
rushing work now.
First occasion also, the no stay order was given.
That is
Now-
of the with
And
their
it is at their
Your
own
Lordship.
risk, so it's their own risk.
No, even if
they
it is at
continue.
your own risk, Your Lordship, there will be lots of complication after succeeding in the case. Also, there will be mis.
If they're willing to take on the risk, then it's up to them. Heard learned counsel for the petitioner, Shri Joshua Sheki, also heard learned government counsel and Miss Such and Such appearing for the respondent number 4. Respondent 4, no?
Thank
you. Who is praying for time today? Government or? Oh. Learned counsel for, on behalf of Tipa Pom. Learned counsel.
Your Lordship, I
government
gave
counsel.
my consent with the condition that I'll request the Honorable Court for status quo.
But when the court has already passed an order saying that no.
No, but
interim
my
will be
lord,
given.
the circumstance has changed. Now they are trying to rush work after the first
So we'll give
report
them
was
only 2
submitted.
weeks.
No, not 2 weeks, Your Lordship. No, my lord,
1 week.
they're asking to be listed on 13th, that is coming
You're saying
Tuesday.
13th.
Yes, Your
Okay.
Lordship.
Learned counsel for the state respondent on behalf of Tipa Pom has prayed for listing the matter on 13th. 13th May. In order to file counter affidavit. So, Joshua Sheki has objected to the said prayer and prayed for a status quo at this stage, as the respondent number 4 is continuing with the work, and there will be complications if this petition is ultimately allowed in his favor. Stop. This court, it is seen that by this court, by order dated
21, my lord. 21 to
21
2025.
to 2025, had stated that the respondent may continue with the work at his own risk. And though the court had found prima facie irregularities in the tender process, no order of stay was given. Stop. Accordingly, this court is not inclined to grant the interim prayer at this stage. However, let the matter be listed on 13th May 2025, and the interim prayer shall be heard on that day.
And Your Lordship, with or without the affidavit, the matter may be heard because this cannot continue. This is to do with the public interest, Your Lordship, not just the right of the petitioner.
You try to file for that. We'll just say it will be heard. Because earlier also it has said the counter affidavit is not required to be submitted in this last order dated 1/5. So.
Your Lordship.
yes.
Obliged, Your Lordship.
If they wish to submit, they can submit.
My lord.
Item number 13.
May it please your lordship. On the last occasion, notice was issued on the prayer on consideration of interim prayer, my lord. This matter is fixed for consideration of interim prayer, my lord.
Lordship, in this matter, I'm yet to receive the instructions with regarding to the interim, in consideration to the interim order, Your Honor. Here, Your Honor, the commissioner is a new incumbent, so I may require 2 more weeks, Your Lordship.
I'm praying for some protection, my lord. At least they should not
take any coercive action against the petitioner, my lord. Matter relates to, my lord, demand of GST, my lord. I can demonstrate, my lord, how this is without jurisdiction, my lord.
You appeal for all the respondents.
Yes, Your Honor.
Where's the impugn order?
That is at page 41, my lord. Annexure G. Actually, my lord,
41. Yes.
section 74 of the by this order, my lord, demand of GST for amount of rupees 58 lakh has been raised, my lord.
In this matter, Your Honor,
Yes.
the petitioner has directly approached the Honorable High Court, but there is an appellate first appellate authority and there is appellate tribunal. However, they have not approached there, challenging this order, which they have challenged here before the High Court. Your Honor.
Well, basically, it's not an order at all, my lord. Lordship may kindly say section 74 of the CGST Act, my lord. That's
No, if there is alternative.
no, I
remedy,
can
yeah.
on similar point, my principal bench has held, my lord, that DRC 07 cannot substitute an order, my lord. It is not an order at all, my. It is a DRC 07, it is a form only, my lord. Summary of the order. If lordship will see rule 142(5), my lord.
From the demand in order to recover such and such. Okay, you take time, but we'll say that no coercive steps will be taken against the petitioner till then.
Okay. Your Honor.
Yeah, that will not harm you in any way.
Yes.
Yes. Heard learned counsel for the petitioner, yes, Ravi Shankar.
My lord.
Ravi Shankar Mishra. I'll just take 5 minutes.
My lord.
break. Mr. Ravi Shankar Mishra for the petitioner. Stop. Also heard Mr. Z. Kolno appearing for the respondents, who has prayed for
2 weeks time.
2 weeks time to receive instruction and to file the affidavit in opposition. Stop. Prayer is allowed. However, till the next date, it is directed that no coercive steps shall be taken against the petitioner.
From the supplementary cost list for admission item number 35.
What is?
Thank you, Your Lordship. My lord, in this matter, I'm aggrieved by the order dated 17 January 2023. My annexure C, page 38.
Annexure?
Annexure C, page 38.
Annexure C.
Yes.
But in the court's copy, it is annexure 1, 2, 3. It is not C. There's no C.
Page 38,
Wait, okay.
main petition.
Oh, okay. G,
G, right, sorry.
Mm.
Yeah.
Mm.
I read out. In pursuant of the government approval, white letter number so and so, that is so and so, Srimati P. Mola from Kisor is hereby appointed as multitasking staff in the district horticulture office Kohima under horticulture department in pay level 1 of the pay matrix, and all other allowances as admissible under the rule enforced from time to time with effect for the date of taking over charge. So this is the impugn order. Now, my lord, coming to my my annexure A. My annexure A, page 15. I've been appointed on 11 April 2000, whereby till date I've put 23 years of service.
Fixed pay.
Yes. Still, I'm in fixed pay after rendering service. Now, my lord, I've made an application on dated 11/11/2021 against the resultant vacancy. That is page 17, annexure B. Annexure B. The subject reads, I read out the subject. Application for a post of multitask
King's staff against the vacancy arising due to retirement of Sri Mr. K. Vitoi Chishi, right, order number so and so. So this release order is appended in page 18. The translated copy, it's page 19. So he has been released. So basing on that, I gave my application. Now, my lord, page 23, Annexure D. Under page 23, Annexure D, the department through the additional director has forwarded the application on dated 27 September 2022. So the subject reads forwarding of applications received for regularization, appointment and appointment on compassionate ground grade 4 post under the Department of Horticulture. So under this, 61 application has been forwarded. So in this 61, my name is reflected in serial number 6. Serial number 6, this is page 24.
Yes.
Serial number 6, Azono Belho.
And the private respondent?
Pardon?
Private respondent is serial number?
Private respondent name is not reflected in this. Subsequently, under page 29, Annexure E, subject, resubmission of application received for regularization. That is on 3rd January 2023. So under this, my name again is reflected in serial number 6. Now here, the name of the respondent number 4 is not been forwarded. Name of the respondent number 4 has not been forwarded from the department. Now, my lord, coming to page 11. Page 10. I would like to read this 12 para and 13 para.
Yes.
I read out. The petitioner sought for regularization, having put 23 years of service and on against the retirement of Mr. So-and-so. Also, the petitioner relied on an office memorandum number so-and-so dated 22nd September 2004. Wherein under the scheme for regularization under para 3 of the OM, 50% of all the regular vacancies of similar nature arising in a year will be reserved for regularization of work charge. Further, the OM also stated that under para 4, work charge employee will have a right to be considered first for regularization against 50% of all the future vacancies. Now, coming to page para 13, I read out that the appointment of the respondent number 4 is nothing short of defiance of the government memorandum, that no procedure is followed as to the appointment of the respondent number 4. And if the respondent does not qualify the criteria of the office memorandum, number so-and-so, dated 22nd September 2004, so also in defiance of the office memorandum, AR-3/GN-174/2007 PT dated 3rd March 2022, wherein recruitment should be routed out through open advertisement. My lord, may please note this. OM dated 3rd March 2022 stated recruitment should be rooted out through open advertisement. Now my case falls under OM dated 22nd September 2004, wherein I'm seeking for regularization.
Under the OM of 22/9/2004.
Yes. So 50% of the thing should be reserved for me. Now, my lord, coming to the affidavit in opposition by the respondent number 4, wherein it is more clearer. Page 9. Page 9.
Yes.
Page 9. This is the circular dated 10 January 2023, wherein 5 members are appointed to be the special committee for appointment. Now, in page 10, annexure 3, the sitting was done on 17 January 2023. My lord, may please come to page 11. Page 11, the second para. I read out, regularization in service, casual appoint employees to be strictly on the basis of OM number so-and-so, dated 22/9/2004. Here, the ratio of the existing vacancies sanction post shall stand at 8-9 for regularization or fresh appointment. Regularization will to be done strictly on the basis of district-wise. Now in the district-wise, I'm the most senior. So here, it is clearly stated that it should be strictly on the basis of the OM. Now, my lord, coming to the last. After scrutinizing all the application, the committee recommended for fresh appointment of 9 grade D posts, 7 MTS, and 2 PCW against the existing vacancies sanctioned post and extra B. Now here, in Annex B, they have recommended number 6. Sri K. Vitoi Chishi, MTS number so-and-so.
Serial number?
6. Serial number 6, page 13. Page 13. Page 13. Serial number 6.
This annexure A and B, annexure A is
Annexure,
regularization.
yeah, annexure A is those people who are already employed. Now, annexure B are the
That's
fresh.
right. Annexure A is for regularization of
Yes.
serving employees.
Serving
and B are fresh.
B are supposed to be fresh. So in number 6, page 13, I've applied in lieu of K. Vitoi Kishi. Now here under number 6, in lieu of K. Vitoi Kishi, P. Muala Pom Kiso, committee recommendation under new appointment quota. New appointment quota. Now, my lord, coming back to coming back to my application, para 13. Para 13. Para 13, if new recruitment is to be done, then the OM is very clear that it should be routed through open advertisement. Now here in this particular case, the name of the present respondent has not been forwarded by the department on 2 occasions. Now all of a sudden the name of the respondent number 4 has been appointed without following due process of law, vitiating the OM.
So that means at annexure A, those who have been recommended for regularization.
Yes.
These are the senior most. So how can you claim as a matter of right?
My lord, here, as stated earlier,
Yes.
I'm the senior most in the department in Kohima. Whereas in the annexure D, that is page 23. Annexure D, page 23. From serial number 6 to serial number 10 is against one post, that is in Kohima.
This list, page
Yes.
24 list.
Yes, page 24. Page 24. Page 24, serial number 6 to 10 is within Kohima. Then in serial number 11, serial number 11 is Zunapoto. Then serial number 20 goes to the same, Jamokokchung again.
Yes.
So as per the annexure 3, page 10 of the thing, the affidavit in opposition of the respondent number 4. Page 11, regularization of in-service casual employee will be strictly on the basis of OM. The ratio of the sanctioned post shall stand as so and so for regularization. Regularization to be done strictly on the basis of
Seniority.
seniority district-wise. Seniority district-wise. Now the case of the respondent number 4. Does not come within this exception of OM.
But how can you claim that you should be regularized against such and such post?
I'm the most
That-
senior. I'm the most senior.
No, even if you're most senior.
And on top of that, her case has never been recommended by the, her case has never been processed from the office. On dated 22nd September 2022, Her name was not in the list. Then subsequently in the resubmission also, her name was not in the list. On the 27th September, 2022, my petition, page 23, dated 27 September 2022. The respondent name was never in the list. This was the list sent by the department to the commissioner and secretary. Then, hereafter, on dated 3rd January 2023, another letter was sent, that is on page 27. On page 27, resubmission of application received for regularization appointment. Page 29. The same name which has been furnished on 27th September has been again resent. Again resent on 3rd January 2023. Yes. So what I'm saying is that her name was never sent, one.
No, but since
two
there is a
occasions,
quota, since as you're also saying, there's a quota, 50-50.
Yes,
50 for
exactly.
regularization and 50 for fresh appointment.
Exactly.
So you cannot claim the post which
Now,
come
that's why,
under,
that's why, my lord, I'm sticking to this, my para 13, OM number AR.
yeah, so you're saying that the post should have been advertised.
Exactly.
The others.
If she is to be, in the case of Kohima, it has to be advertised. Now, without the advertisement, without the, without her application being sent, she has been appointed. Now I'm seeking on the basis of seniority. I've been serving in the department for 23 years. And it has been acknowledged by the department that I'm the most senior. And in the in the special committee, it's very clear. The guideline, I mean the recommendation is very clear. It should be the appointment should be on the basis of OM dated 22/9/2004. This is very clear. And on top of that, it is stated, it is clearly noted that basis of seniority district-wise. Page 11, affidavit in opposition of the respondent 4.
So accordingly, at the next year A, the senior most from each district has been accommodated, isn't it? MTS seniority number 1, Procedural. MTS seniority. SHN. What is SHN?
My lord,
SHN Dimapur.
I'm new to this.
MTS seniority Longnak. MTS seniority Zemnaputo.
My lord, if we read out this thing, the minutes of the meeting, yeah, that is in page 10.
Yes.
May I read out?
Yes.
It's 2 page.
Yes, yes.
Yeah. A meeting of special committee was held on 17 January in the office of the Commissioner and Secretary Horty. Under the chairmanship of the Commissioner and Secretary, the chairman welcomed all the members and gave a brief introduction on the issue. Attendance is annexed. Initiating the discussion, the Joint Director and head of department informed the members that at present there are 17 grade 4 posts vacant under various establishments against which the department is in the receipt of 69 applications. Now, my lord, coming to the application sent from the department was 61. 69 application from in-service fixed, casual for regularization, fresh appointment and appointment on compassionate ground. At present, there are 147 fixed, casual, grade 4, grade 3 and grade 4. Many of these employees are serving more than 20 years. It may be noted that some have died in harness before regularization of the service. It may be mentioned that due to freezing of all fresh appointment by AR number so dated dated 22/4/2020, the department have not taken up for appointment of Group D posts for the last 3 years. As such, there is a huge shortage of grade 4 employee in many establishments, which is affecting the smooth functioning of the office. With relaxation to the bound of appointment by number so dated 27/5/2022, it was decided to take up for regularization in service, casual fixed pay, and fresh appointment of all the grade 4 vacant sanctioned posts as per existing policy of the government. Now, my lord, I'm coming to this 3rd March 2022, wherein it should be routed through open advertisement. The department by number so dated 17/1 has requested to review the administrative approval for regularization of Shri so casual MTS serial number 7 in the seniority list under HRF role conveyed by office letter number so even dated 16/1/23 as it is not in consonance to the OM number so dated 22/9/2004 policy and scheme for regularization of service of work charge employee as per para 3 and 4 of the aforesaid mentioned OM. 50% of the regular employee will be reserved for regularization of work charge employee, and regularization will be conducted on the basis of seniority come merit. Therefore, regularization of serial number 7 superseding the other casual MTS senior to in is against the above OM. It may also invite legal lawsuit. It may be mentioned that serial number 1 and 2 of the seniority have served more than 3 years, wherein 3 Nicolo Mero has served only 3 years. Moreover, he has not been allotted permanent PIMS court. After thorough deliberation, the committee decided on the following. Since the regularization of Nicolo Mero, casual MTS serial number 4 is the senior in the seniority list is not in consonance with the above mentioned OM. Therefore, it was decided to quash the administrative approval conveyed on the date so. Regularization in service of casual employee to be strictly on the basis of OM AR number so dated 22/9/2024. Hence, the ratio of the existing sanction posts shall stand at 8/9 for regularization for fresh appointment. Regularization to be done strictly on the basis of the basis of seniority district-wise. The committee, after thorough scrutiny of the seniority list, recommendation of the regularization of 8 in service casual fixed pay employee as per seniority district-wise. Annexure A. So Annexure A is district-wise. Now here in Annexure A, district-wise of Kohima is not been there. It's not there. Page 12. page 12. Number 1 is Procedural. Number 2, Procedural. Then number 3 is under SHN, SHN, then Longnak, then Zenoboto, Mokokchung, Tingsang. So here it is stated it will be district-wise seniority. Now, I further read.
Yes.
Rationalization and redeployment of force for non-functional establishment units and establishment as with excess manpower to establishment where there is accused shortage was also discussed in length. FCF Loknak has been line idle and non-functional. Moreover, DHO Zenoboto has excess MTS, therefore it was decided to transfer three vacant posts, group 1 MTS and 2 PCW from FCF Loknak and 1 post of MTS from Zenoboto, DHO Zenoboto to HSHN Dimapur since the available grade D employee under SHN Dimapur are not sufficient to man the nursery. After scrutinizing all the applications, the committee recommended for a fresh scrutiny of 9 grade D posts, 7 MTS and 2 PCW against the existing vacancies, sanction post and Annexure B. The meeting ended with thanks from the chair. So, as per Annexure A, it should be district-wise. Here, under the district-wise, my name is not been reflected. Now, in Annexure B, serial number 6, the respondent number 4 has been recommended. Committee recommendation under new appointment quota. So under new appointment quota. So if it's under new appointment quota, the appointment of the petitioner, the respondent. So under what quota? If it's supposed to be under AR-3, OM AR3/GN 174/2007 PT dated 3rd March 2022, then it should be routed through open advertisement. The exceptions are: 1 will be the landowner. One will be
The state respondents have stated that you could not be accommodated because it was done on the basis of seniority. So how do you say that you are the senior most in the district? Seniority list is there.
Seniority list has not been given, but yeah, I think so. I'm coming to that.
Okay, so
Yeah,
your case
seniority
is that
list is in page 45.
Hmm.
45. My name is marked under serial number 1. I'm number 4. So MTS. So my appointment is in 2000, in the year 2000, 11/4/2000. So taking into account of the other MTS, I'm the most senior.
Okay.
Yes.
So your case is that you are senior most. So that means these others who were considered, they are junior to you,
They are from another district.
another district.
Yes.
Okay.
I'm from Kohima district. So as per the committee minutes, it should be district-wise. They've stated very clearly that it will be district-wise. So as per the annexure A, Kohima district, there was no the same, no seniority was given. And the appointment of the respondent, appointment of the respondent, if at all, it is done under 3rd March 2022 OM, then it is okay. But it was not done. On top of that, her name was not the thing sent from the department to the commissioner secretary. Her name was not there in the list also. And all of a sudden her name came up and her appointment has been done.
No, as far as you're concerned, you
Yes.
can only lay claim to those posts which are meant for regularization.
Yes,
Certain posts which are meant for direct recruitment, you cannot claim.
I'm not claiming for
You
that.
cannot
Yes.
claim.
Yes,
But when the appointment of the private respondent is made against the post which was meant for direct recruitment,
yes.
then how can you challenge that
No,
appointment?
see, what I'm saying
You
is
can
that
always claim for regularization. That's a different
I'm
matter.
claiming for that.
Yes.
If at all,
But challenging the appointment of respondent for which is outside your quota, which is not coming within the regularization quota, then
no, my lord, that's why I'm saying. If at all, the appointment of the president.
because you cannot say that this particular post is direct recruit quota, this particular post is for regularization. That only the authorities can decide. Isn't it?
Of course,
Yes.
but here, in my case, since I'm the most senior, this is one.
Okay.
Number two,
That
if
is.
at all,
Mm,
if at all,
mm,
the respondent is to be this thing appointed,
mm.
why didn't the department go for advertisement as per the OM?
No, for that matter, if you're challenging that, then all of them who have been appointed directly, all those posts have to be advertised, not only
Exactly,
the private
exactly.
respondent.
Yeah.
Okay, let's hear the government.
Your Lordship, initially there were 17 vacancy in the department from various establishments. So for these 17 vacant posts, there were 69 applicants, Your Lordship.
How many
have-
vacancies initially?
17, Your Lordship, from
17.
various establishments of the department, okay?
Yes.
And for that, the department received 69 applicants.
69
Yes, Your Lordship, 69 applicants. Annexure A is the list of applicants that were received, both from in-service employees as well as fresh appointments and compassionate ground. Now petitioner is at serial number 6.
Serial number 6, yes.
And private respondent number 4 is at serial number 63 in my next year, page 14. Now petitioner did not enclose the last sheet of the list.
Okay. Respondent is that? Oh, 63. Yes. Next year A.
Yes, Your Lordship. Now having 17 vacancies, the government, through its circular, constituted a special committee. The government constituted a special committee to look into this matter, Your Lordship, to consider the case for regularization of in-service employees and fresh appointments. So through its meeting minutes on 17/1, 2023. That is my election number 2. The committee decided that for regularization of in-service employees, it should be strictly done on the basis of OM 2004. And hence the ratio for the 17 posts was divided as 8:9. 8 for in-service employees and 9 for fresh recruits. So among the 8 regularization posts that were regularized for in-service, the petitioner could not be accommodated because there were other senior employees from this various districts also, Your Lordship. And respondent number 4 was appointed from among the 9 posts that was for fresh appointees, Your Lordship. So here petitioner has no locus standi to claim the for regularization against the post of respondent number 4, Your Lordship, because these two are from different quotas, Your Lordship. And the meeting minutes also clearly stated that.
If you come to your annexure 3, annexure 3, and the annexures which are enclosed with that,
Yes, Your Lordship.
it shows that 2 persons each from the same place have been accommodated. Why is that? Because one is also from seniority 1 from Futsuro, HRF Futsuro. Serial number 2 is also from HRF Futsuro, where they are seniority 1 and 2. Then 3 and 4 also from under SHN seniority number 1 and SHN seniority number 2.
Your Lordship, these were done as per the seniority list compiled from all the districts, Your Lordship. And the vacancy that arose in Kohima was given for fresh recruitment, fresh appointment, Your Lordship. The petitioner claiming the post, the vacant post of Sri Vitoitishi, that is from Kohima. And that post was given for fresh appointees, Your Lordship. And with regard to the employees for regularization, this was done by the committee, Your Lordship. They selected as per the seniority list, Your Lordship.
That means all these people in annexure A are senior to the petitioner.
Yes, Your Lordship. This is the list that the committee selected after compiling all the seniority list.
Because the list, this 63, 60 something, consisting of 69, this doesn't show like, because these are all mixed up.
Yes, Your Lordship, this is all mixed up.
So this doesn't show the seniority at all.
Yes, Your Lordship, it does not show the seniority.
So how will we know that these people are are senior to the petitioner? Because that is the only point. Challenging the respondent, that is a different thing.
Yes, Your Lordship.
He has to show his locus. So for that, he has to show that he is the senior most, and that these people are junior to him. These people at the annexure A. But this doesn't show.
Yes, Your Lordship.
Yes. Can you show
Okay, Your
any
Lordship.
document by which the court will know that these people are senior?
Yes, Your Lordship. Then if I may give some time to place on
Because
record
it's
the
not
seniority
clear at
list.
all from here. How much time?
Your Lordship, 3 weeks time may be given.
3 weeks.
Because this will be a compilation of all the seniority list from
Yes,
various
it has to
districts.
be, it has to be, and you have to show that these people at annexure A were senior to her, that's why they were regularized. Otherwise, in your, this circular, I mean, the committee minutes, it is set seniority district-wise. So that means they have looked at the seniority of all the districts and chosen the senior most. So you have to show that. Okay. Learned counsel for the petitioner, Sri Level Zhao, also heard MS, I keep forgetting your name. AIME for the state respondents, and Mr. Tongpok Punguner for the respondent number 4. Respondent number 4, no? The state respondents are given 3 weeks' time to produce a copy of the common seniority list showing the seniority of the petitioner vis-a-vis the seniority of the 9 employees, 9 of them, no, or 8 of the 8 employees who were recommended for regularization by the special committee constituted by circular dated 10th January 2023. Stop. You can file an additional affidavit. The state respondent shall file the same by way of affidavit.
For orders, item number 14.
Your Lordship, I'm appearing on behalf of MT Wapang. If a week's time may be given to file Bakalatnama for respondent number 1.
Respondent number 1.
Yes.
Your Ladyship, with regard to respondent number 2, 3, and 4, even on last occasion, before the appeal was dismissed, and in learned trial court as well, despite having served notice through paper publication, they failed to appear.
They didn't appear.
Yes, and it is very likely even today they might not appear. Therefore, if this matter may be taken up without them or proceed ahead.
Learned Counsel, MS
Your
Secretary.
Ladyship,
Yes.
if I may intrude, I have a small prayer with regard to amendment of course title in IA 35. Inadvertently, I have made a clerical error in condonance of delay, which is supposed to be 546 days and not 552 days. In my course title as well as in para 4, the last line. Therefore, if I may be allowed to amend the same.
You have written 552.
Right.
Instead of
564.
564. Okay, we'll come to that. Our learned counsel, MS such and such, who enters appearance on behalf of respondent number
1, Your
1
Lordship.
and has prayed for how much time?
A week's time, Your Lordship.
A week's time to file Vakalatnama and written objections. Are you objecting? And written
Yes,
objections,
yes,
if
Your
any, if any. Prayers allowed. So, the learned counsel for the petitioner, Mr. James
Nimai,
has stated that there is a mistake in the course title where he has inserted, where he has stated that there is a delay of 552 days. However, it should have been 564 days.
And in para 4.
And also at para 4 of the IA
35.
The delay has been mentioned as 552 days, and it should have been 564. He has therefore prayed for amendment, prayed for permission to amend the set numbers. The petitioner is allowed to amend the set error in the application. You just amend it by hand and put a signature. Okay. Stop. As regards the notice on behalf of, noticed on respondent number 2, 3, and 4, learned counsel for the petitioner states that they had not appeared before the trial court also, in spite of notice by paper publication. Stop. And please that the notice on the respondents 2, 3, and 4 may be deemed served. Stop. But the trial court records are not here now. It's here. Trial court records haven't come now.
However, even on last occasion before the MAC appeal was dismissed, Even in that occasion, like we have served through paper publication, however, they failed to appear.
They are residents of Nagaland? No.
No,
Some.
2 from Gauhati, Assam, Gauhati, and 1 from Soitpur, Assam.
In that case, you take steps again, then by substitute summon, paper publication. And then after that, we'll deal
Yes,
with
Your
serve.
Ladyship.
Because at this point, we can't say, because the court records are also not here.
Yes, Your Ladyship.
In the judgment, is anything stated about that in the impugned
Yes,
judgment?
but however, that is in trial court judgment.
Accordingly, the petitioner, the applicant is directed to take steps for notice on the respondents 2, 3, and 4 by way of substituted summon, by publication. Oh, it has to be Gauhati paper, Assam paper.
Gauhati.
By publication in
Local dailies.
the local daily circulating in the state of Assam. Release the matter after 3 weeks.
Much obliged.
From the supplementary cost list for orders, item number 36.
Please, Lordship. Lordship, the leading counsel for the petitioner, Lakne Pom, is indisposed. So if this matter can be passed over for a day.
Mention is made on behalf of the learned counsel for the petitioner that he is indisposed. Accordingly, pass over for the day.
Thanks, Lordship.
For hearing, item number 22.
May it please your lordship. Lordship, may kindly have a look at the last order, which was passed on 9/4/2025, your lordship, yes. A direction was given to the state, to the council for the state respondents to bring instruction, your lordship.
Yes, para 6.
Yes, your lordship.
State respondents, yes, Mr. Moore, state respondents shall verify the claim of the petitioner in terms of the said judgment and order, such and such, and the honorable division bench, such and such, SLB, and shall apprise this court as to whether the petitioner should be granted similar relief as has been held earlier by the learned single bench. So is it similarly situated?
No, your lordship, when this order was passed, I was not there. So I'm handling the case. Now, lordship.
Livika was there.
Livika was
Yes,
there.
yes.
So it is like this. There's a regularization of a work charge employee. They made a pretense of regularization of a work charge employee. Now, we have filed writ appeal 2, 3, and 4 before this court.
Those who have served for 30 years or more. Isn't it 30 years or more?
Petitioner is now already out of service.
Okay.
Lordship,
Okay.
I'm seeking for retrospective regularization, your lordship.
After serving for 30 years.
Yes, 35 years. your lordship.
35 years. I think these type of cases you are taking up, isn't it? In those other petitions, in those other writ appeals and all.
Same regularization,
Yes,
not
same
only
matter.
department is different.
Only-
This
yes.
is MPWD department. Now, in PH department, we have filed the appeal. Mrs. Veshakuri is handling this case. Now, Lordship, may kindly see this, the order. We have filed the appeal.
Okay, an appeal is pending.
Appeal is pending, appeal is pending, appeal is pending. That's why. Read appeal 2, 3, and 4.
With regard to PHE.
It is pending.
So what about this WPC 21 of 21 and read appeal 35 SLP?
Your Lordship,
This-
if I may kindly be
Yes.
allowed to apprise this honorable
Yes.
court, Your Lordship.
Yes.
So, Your Lordship, the learned single judge, Your Lordship, of this honorable court, had, in a similarly situated case, has given a direction to the state respondents to regularize the service of the petitioner, Your Lordship. However, being aggrieved the state government, Your Lordship, they have filed an appeal, which was dismissed by this honorable court, the division bench of this honorable court, Your Lordship. Again, against the state dismissal order, they have filed another SLP before it.
SLP, huh.
Yes, Your Lordship, the Supreme Court, which was also dismissed, Your Lordship. So it is my humble submission that the state has filed an appeal, Your Lordship. I'm representing the state respondent in that case also, Your Lordship.
Okay.
So, Your Lordship, it is my humble submission that the same grounds which was raised before the division bench of this honorable court, Your Lordship, and which was decided by the division bench of this honorable court, they are raising the same grounds against, Your Lordship.
Again in this read appeal also.
Yes, Your Lordship. The only new grounds that was raised by the state government was that the question of law is left open, Your Lordship.
Lordship, this is the SLP order in the SLP filed by the state. Lordship, may kindly see the para 3 of the Honorable Apex Court's order. While we are not inclined to interfere with the ambient judgment in the order passed by the High Court, that means the division bench, the cautions of law raised by Mrs. M.S. Inaturisima, learned advocate and the court, are kept open for being considered in an appropriate case. That means that the interpretation, the SLB was dismissed, but the caution of law was been kept open. That is why we have filed this writ appeal before the division bench. And the division bench has admitted the petition and has, as we have said, the Lordship has said, has notice was been issued. And the petitioner counsel, I think they are one of the counsels in that appeal also.
Your Lordship,
No, see,
if
the
I,
thing is, if this is covered by that WPC 21 of 21 and the other series of cases, then this one also has to be disposed in that manner.
yes, Your Lordship.
Yeah. You're also admitting, isn't it, that
That is
the
up to
facts
your
are the
Lordship.
same?
That is up to Lordship. But my prayer is that why not wait for the
Wait for the disposal of
the
this.
writ appeal, 3 writ appeals, which is pending before this court.
Your Lordship, even otherwise, there's a decision, 3 judge bench, the decision of the Supreme Court, Your Lordship, in Prem Singh versus State of UP, Your Lordship, 2019-10 SSC 516, Your Lordship.
On what proposition?
Your Lordship, even in that case, it was decided that, Your Lordship, a word charge employee who has served for more than 3-4 decades, Your Lordship, is deemed to be a regular employee. Your
We are
Lordship.
not disputing that. We're not
Yes, Your
disputing.
Lordship.
As it is, there are so many judgments of this court also, division by SLP, but only on the thing whether to keep it pending or whether to dispose, because even if we dispose it, they'll again file an appeal against that also. So
Yes,
if we keep it pending till the disposal of this writ appeal, then that will cover your case also, isn't it?
Your Lordship, it is my respectful submission that the decision of the division bench of this honorable court is still holding the field, Your Lordship. So, however, several rounds of litigations are being filed by the state in order to, I respectfully submit that it is a delay tactics, Your Lordship, in order to not to grant me my rightfully entitled pensionary benefits, Your Lordship.
Lordship, because your Lordship is well aware, there is no notification or office memorandum or any standing policy of the state to regularize a work charge casual employee who is not enjoying a scale-up pay. Someone who is enjoying a scale-up pay and serving for more than 30 years can be regularized. That 2015 OM is there. Otherwise, there is no OM at all.
No, but employee after serving for more than 30
Granting
years,
for
how can you
scale-up pay,
judge?
granting for scale-up pay is there.
But regularization of a casual employee, work charge employee, direct regularization is not there. There is no standard policy at all. The petitioners are just citing the apex court ruling. And as you have seen, Your Lordship, the question of law is open.
Question of law of what?
Question of law of regularization of casual work charge employee.
But you're not disputing also, isn't it, that similar petition was allowed and then the writ appeal also, your writ appeal dismissed,
Your
SLP
Lordship,
also dismissed.
I kindly appreciate the difficulty of the government also. Once this is allowed, the present petition is allowed, when the appeal is pending for the same question of law, then it will open a floodgate for, because most of the cases here are about this only. So it is a very sensitive issue. Because if we keep on going regularizing the work charge casual employees, then it will set a
This writ appeal 3
precedent for
also, writ appeal 3 of 25. Here also the petitioner was on fixed pay.
Yes, Your Lordship, fixed pay.
And retired.
Yes, Your Lordship. They're all for retrospective regularization, all the three writ appeals, Your Lordship. It is similarly situated with the present case, Your Lordship.
Then I think it's better to keep it pending because even if it is allowed, they will again file a writ appeal against that also. Ultimately, it will be the same thing.
Lordship, what I find is the petitioner should have sought before this honorable court for grant of scale-up pay. Once scale is granted, scale-up pay is, granting of scale-up pay is there, notification. Once scale-up pay is granted.
That March
Yes, that March and 3rd May also there. 3rd May, that is very recent one.
Your Lordship,
No, but when he's already retired, then how can scale of pay be given after retirement?
Petitioner is a work charge casual employee and is out of service now. And he is seeking for his regularization. The petition itself is defective. He should have sought for scale-up pay, and then regularization would happen automatic. But he's seeking for direct regularization.
Your Lordship, in the present case, I'm also challenging the office memorandum, Your Lordship. 17/3/2015, Your Lordship.
I think it's better to keep it pending. Heard learned counsel for the petitioner, Miss Annie Thire. Also heard learned senior government advocate, Shri Moinchin. On 9/4/2025, this court had directed the state respondents to verify the claim of the petitioner in terms of the said judgment and order of the learned single judge dated 11/4/2022, passed in WPC 21 of 2021, the judgment and order dated 6/2/2024, passed by the Honorable Division Bench in Writ Appeal 35 of 2022, and the order of the Honorable Supreme Court, Right Order dated 15/1/2025 in SLP Civil number 22747 of 2024, and to apprise this court as to whether the petitioner should be granted similar relief as has been given by the learned single bench in WPC 21 of 2021, via judgment and order dated 11/4/2022. Stop. The learned senior government advocate, Shri Moinchin, at this stage has drawn the attention of this court to the order dated 15/1/2025 passed in SLP 22747 of 2024, by which the Honorable Supreme Court had stated that, and then you quote this para 3, okay? Therefore, Learned Government Council states that the state respondents have filed. When was that order?
Writ appeal.
Yes.
Your Lordship.
Writ appeal 3, no?
To
Writ appeal 2,
2025,
2 and 3.
2024, I think. Writ appeal
Writ appeal 3 of 2025. Before the Honorable Division Bench. Wherein similar questions of fact and law have been taken up. So he submits that by an order dated 30/4/2025, the Honorable Division Bench has issued notice and the matter is still pending. Stop. Accordingly, he prays that this petition may also be kept pending till the disposal of the writ appeal 3 of 2025, as it raises similar questions of fact and law. Stop. Therefore, this matter after the disposal of writ appeal 3 of 2025. I think that will be less problematic for everyone.
After the.
Last edit. What did it everybody? I was it.
Yes, you're ready to hear.
It's a short matter,
Very
Lordship.
short.
I'll take only 15 minutes.
Let's see.
Lordship, before I come to the facts, Lordship,
Mm.
matter pertains to commissioner appointment.
Mm.
And I'll take your Lordship attention to the OM, which cover my case, Lordship.
Yes,
Page 16.
16.
Yes, Lordship.
This is the latest one, no? The
Yes,
new one.
latest one, OM. This is the OM dated 17/9/2015, Lordship.
Mm.
I'll refer to first paragraph and fourth paragraph, Lordship.
WBC 143. Yes.
Near Lordship.
Mm.
And supervision of this office memorandum even number dated so the Governor of Nagaland is placed to revise the existing scheme for appointment on commissioned ground of family members of the state government employees who die non-harness as per guidelines enumerated below. Number two, appointment on commissioned ground shall be given to one of the following members of the deceased employee's family. Number one, number A, spouse,
Son.
number B, son, number C, daughter. I'm the son. Now come to paragraph 4. Commissioned appointment may be made due to both falling under the combined direct recruitment quota of Group C or D. The ceiling for a commissioned appointment of 5%. Earlier it was 5%.
Yes, yes.
Of the direct recruitment vacancies in Group C and D, what has been done away with provided such appointment do not exceed 50% of the vacancies during a year. So it has been increased to 50%, Lordship.
Why did such appointment during the year?
Earlier it was 5% only.
Yes.
By this,
Now it is
50%.
50%.
So I'm the son of the deceased government employees, Lordship.
Mm.
My father expired in the year 2019 while serving as telephone operator Miscellaneous under the Home Department. After the death of my father, Lordship, I submitted my application for appointment. However, despite less of time, my case was not considered. Therefore, I approached this honorable court by filing this writ petition praying for commissioner appointment under this case. What happened, Lordship? By filing affidavit in opposition by the state respondents, that includes the seniority list as
Yes.
well as
Each department is supposed to maintain a list.
yes.
Yes.
Before I refer to the seniority list where my name is reflected, it's number 7, page 6 of affidavit in opposition, Lordship.
Of the government respondents.
Yes, Lordship.
Yes. Page 6.
Page 6.
6, Lordship.
So my name is at cell number 7.
7, okay.
Now, seniority list includes 23 versions for appointment and commission. Next page, Lordship. 23
23 of them. Yes.
of them. Come to page 8. Actually, Lordship, before filing this writ petition, I submitted an application under RDI seeking information about the vacancies available, which was not furnished to me. However, by this page 8, the information has been furnished here, Lordship. Here, Lordship, page 8. Detailed statement of grade 4 vacancies since 2019. Affidavit and opposition was filed in the month of January 2023.
No.
2024, sorry.
25.
No, 24. Affidavit and opposition was filed
Affidavit in opposition.
on 30th of January 2024.
No. Respondent 1 to 3, isn't it?
Yes.
3rd February 2025.
No, in my copy, it is mentioned as 30th of, it was filed, I received on 21/25. However, in the affidavit and opposition, and I sent this affidavit.
Here, the filing.
Swearing of the affidavit, Lordship. Swearing of the affidavit.
Oh,
Page 5.
yes.
In my copy, 30th
Swearing
of
is
January.
3rd February.
Yes. Therefore,
2025.
page 8, come to page 8, Lordship. Detailed statement of grade 4 vacancies since 2019. Next page, Lordship, page 9.
Yes.
Altogether, 60 vacancies arose from 2019 to December 2024, December 2023. 60 vacancies till 2023. Has Lordship got it?
Yes.
Therefore, Lordship, as per the scheme, out of 60, at least 20 posts should be reserved for the commission appointment. What happened, Lordship? Next page, page 10. MDs appointed under the scheme for compassionate appointment under so-and-so Home Department. 15% were appointed, Lordship. However, Lordship, after 2019.
You're also claiming under this Home Department?
Yes. However, after 2019, Lordship, only serial number 13 was appointed on commissioned ground. Serial number 13.
2022. Yes. The others are all before that.
Yes, Lordship. Therefore, Lordship, the boss meant for commission appointment has already been filled up by other source. And to do contrary to the office memorandum, Lordship. Therefore, Lordship, this honorable court on 28/4/2025.
Where is that?
Order dated
Court order?
24/5/2025. Direction was issued to my learned friend government. Yes. To ascertain the vacancy position.
Which date?
28/4.
28/4. Oh, it's 28. Oh, yes.
To get instruction about the vacancy position from 2020
20 till date.
till date.
And as to whether the appointment has been made to the said post and the number of
Yes.
posts against which compassionate appointment has been made. Okay.
And this morning, Lordship, I've received a copy furnished by my learned friend where it has been provided that there are 24 vacancies available now. under the Home Department.
Page 3, Lordship. Page 3. That's the status report.
From 24 till date.
24 vacancies available now, Lordship.
Okay. And then what about those who were above you in the compassionate
They are yet to
appointment
appoint,
list?
do it to be appointed, Lordship. I'm at serial number 7.
You're at serial number 7.
Yes.
So the ones who are above you have to be considered first.
Lordship.
This serial number 1 to 6.
Yes, my submission, Lordship, from 2019 to 2023, all the boss men for the commission appointment has been filled up,
Okay.
except one appointment on commissioned ground. Now that there are 24 boss available to be filled up in the, under the Home Department, my humble prayer and submission before Lordship is to consider the commissioned appointment first under as per the office memorandum, whereby it has been provided that 50% has to be given to the commission.
Out of this
appointment.
24,
Lordship.
at least 10 you have to
Yes,
consider,
Lordship.
na?
Lordship,
For
less than.
compassionate.
since I agree with my learned senior, since 2020 to 2023, if you see the status report, yes, 60 vacancies have come up. And probably they have appointed 2 of them. That one in the last page of my page 4, the status report. One have sent for the recommendation. They have recommended for the appointment.
Status report. Page 4.
Lordship.
Okay. So this is Defunil. But his name is not here.
Yes, that now they have made it this roster list after sending the petitioner. No, the first person. Now petitioner is in serial number 7, Lordship. So now it's up to the court to follow the OM by giving a direction to the department.
No, the court can always give a direction
Lordship.
to consider.
Lordship.
But the thing is, what I'm saying is, since now there are 24, as of
Lordship.
now, there are 24
Lordship.
vacancies. So out of that, if we go by the OM, at least 10 should be
Lordship.
reserved for the compassionate. So in that case, petitioner stands at serial number 7.
Lordship.
So all these 1 to 7 should be considered, isn't it, actually?
Lordship, here the problem for the department is landowner. It used to come in the 4th grade landowner and some local people. So for department also they are having a problem. But with the direction, without putting a 10 of that, if you can direct to follow with the strictly with the OM,
Strictly with the OM.
Lordship, that will be much
No,
appropriate.
Lordship, see, earlier precedents also, Lordship is already observed. Out of 60, only one post was given to the commission appointment. If this practice is allowed to continue, Lordship, I will not get appointment even in coming 10 years, Lordship. Therefore, a strict direction should be issued by this honorable court, taking into consideration of the precedents followed by the respondents and contrary to the office memorandum, which was your office memorandum, Lordship. Office memorandum doesn't speak about land ownership. It speaks
there
The
about
weekend, in fact, it used to be the vacancy, which for the 4th grade.
admittedly there are 24 vacant posts, Lordship.
Okay, we'll dispose it off, but how much time will you require for consideration? 3 months?
No,
4 months?
Lordship, 6 months.
No, Lordship, vacancy is
6
there, Lordship.
But procedure will be there.
But procedure is there, the
Lordship,
file
you
processing.
have to
and
go
all
to
that.
the government level. So
Lordship,
And
instead of 6 months, 4 months will
because
suffice. Lordship.
we also processed 2 compassionate appointments for district court, and it took us 6 months
Lordship.
to go to PNR and come back and issue the appointment
Then 5 months,
when I was in law department.
5 months.
So it takes time for them. So 5 months.
Yes, Lordship. That is
6 months will be
that is
appropriate.
reasonable. That is
Since it
reasonable.
will be on the safer side for port.
Okay.
I'm waiting
yeah.
for appointment since 2019, Lordship.
See, just go. I'll just pass order in the chamber.
Lordship.
Lordship.
Yeah. Your name is?
Achungli. Why Achungli?
Sanctum.
Lordship.
You are government advocate.
Lordship.
Heard Learned Counsel, Mr. Wati Jamil for the petitioner. I also heard Mr. Y. Achungli Sanctum for the government respondents. Petition is disposed. Order in the chamber.
Obliged.
Just throw this also.